And I have the distinct privilege of introducing Frank Coleman. And I'm actually taking the place of Chip Pocock, who requested this introduction but was not able to be with us today due to a death in the family. So we're missing Chip here, but I'll try to introduce Frank. Frank is a management labor law attorney and litigator. He's defended employers in court and before government agencies around the country. He's lectured nationally on labor law, employment discrimination, occupational safety and health. He writes regularly for several trade associations and trade publications. His law firm, Coleman & Saucier, PA, maintains an interactive website at www.colemanlaw.com. Their firm is recognized nationally in labor and employment law. He's practiced law in Maryland since 1977, a graduate of Johns Hopkins University and Syracuse University College of Law. And that's the official intro of Frank. And the unofficial intro is that Frank is not just an attorney, he is a friend attorney, and you may not have many friend attorneys, but Frank is in that category. He has been a supporter of Steel Erectors Association for many, many years, spoken at many of our conventions, seminars. He has been around with us. He's our expert that we turn to. And many of you erectors out there, when you've had problems, Frank is the guy that you've called. And so he has just been a great asset to our organization, and we're just glad to have him. And so let's give Frank a welcome round of applause.
Thank you. Okay. Well, those of you who have heard me before, and my God, I can see a lot of people who have heard me before, know that I never know where any of these things are going, right? I'm like Mr. Wolf in Pulp Fiction. I talk fast, I think fast, I make quick decisions. So feel free at any time if I say something that you have a question about, interrupt. I have a very difficult time staying awake for a full hour, but I assure you that I will be done at 11:30 because I believe that start time is sort of iffy, but quitting time ought to be quitting time. Plus you guys have a trade show to go see. But what I think brings me here today to give my Osha talk, which I have updated and I hope will make even more interesting, including to the people who've heard it before, is that big labor, AFL-CIO, the Service Employees Union, the iron workers, whatever, they believe that they're the reason why Barack Obama was elected president. And one of the most liberal newspapers in the world, called The Economist, this is where I got this picture from, says that the only people who seem to have the ear of the president is big labor. And even they're against it. Okay? And they say that, look, you can't have an economy like this and worry about all of these liberal union agenda items. Unfortunately, I don't know that anybody is listening to The Economist on that, because the person who's been appointed to be Secretary of Labor is Hilda Solis. And if you can see, this picture was taken at a convention of the AFL-CIO. And during that convention, she said, OSHA is back in the enforcement business. Okay. Now, it's kind of funny. When Barack Obama was elected president, I was sitting at a table with some arbitrators and some union people at one of those dinners where they get people together who hate each other in the hopes that they can play nice. Okay, so we're sitting at the table, and one guy says, well, employers have had their way for the last 8 years. And I looked at him, I said, are you out of your mind? How many people feel that you've had your way for the last 8 years? How many of you think that under George Bush, your life was easier with respect to OSHA? Okay? And how many people here do not like to raise their hands in response to questions? No? Okay, there you go. All right. But, okay, well, they're back in the enforcement business. I don't know that they ever left the enforcement business, but this is what the Secretary of Labor is saying. She's saying there's a new sheriff in town, whatever the hell that means. Okay, this is pending in Congress right now. Protecting America's Workers Act House Bill 3160, hearings held last week that would amend the Occupational Safety and Health Act in ways that I'll tell you about in a minute. Now, I know that's ridiculous, right? We would never elect anybody from Saturday Night Live to Congress, correct? All right. Senator Al Franken from Saturday Night Live. These are the people who are deciding what OSHA should be. The key provisions of the change that's pending is that OSHA would now apply to federal, state, and local employees. Does anybody care? No, I don't care either. All right, except I can see where the government can become even more inefficient if they're now subject to the labor laws. Several years back, I was involved with a trench collapse, and a state trooper jumped into the trench to rescue the worker. And Maryland Occupational Safety and Health cited the state police under the trenching standards for endangering the life of a state trooper. As all of you know, and I'll allude to it later, the days of heroic rescues are over, correct? You have a building collapse, you have an accident, and fire and police are going to want to keep you away. They're going to want to make sure it's safe before anybody goes in to do a rescue. Well, under the Maryland Act a few years ago, state police got cited. Under this, that means that they would now have a federal OSHA citation. Also, felony charges. You are all aware that if somebody dies as a result of a willful OSHA violation, the principals of the company can go to jail. All right? 3 months. It's a misdemeanor, but 3 months in jail. This will change to being a felony, 10 years. Mandatory inspections for serious injury or death. Now, I don't know how big a deal that is. Whenever there's a fatality, there's an OSHA inspection. You know, I don't care. I don't think they have to have that in there, except it will now be required. Whenever there's a serious injury or a death, there has to be an inspection. Family participation in settlement discussions. This is going to be very, very weird. If there's a fatality on a job site, what this means now is OSHA can't settle the case unless they involve the family in the settlement negotiations. Can you imagine how horrible that's going to be? I've been involved, I think almost everyone here at least knows of someone who's been involved in a fatality. And they look at me like I'm the creepiest person on the planet while I'm defending the company, you know, for a death. You can imagine how difficult it's going to be to settle OSHA cases if this family participation gets through. Okay. Well, let's go to how to deal with OSHA. We all know why OSHA shows up. Either there's a complaint made by an employee, complaint made by a labor union, complaint made by whoever. Accident, you know, if there's an accident on a job site, who does the fire and rescue and the police call as they're riding over to investigate? They call OSHA. So usually there's an accident investigation. General scheduled investigation, follow-up investigation, and consultation services. Those are usually the 5 reasons why OSHA would show up. Okay, and this is it. Sometimes a complaint investigation can be done by a compliance officer just driving around. As you know, there are certain OSHA guys who like steel, and every time they're driving around, they see a building going up. You know, they look at it and half the time I say, it was a complaint investigation. Well, who complained? I did. All right, so you can get a complaint investigation from an OSHA inspector. And like I said, a union, if you're a non-union operation, that's certainly a way for the union to give you some trouble and sort of set you off base a little bit, is to contend that you're doing something wrong. Accident investigation, police, fire, emergency personnel. And like I said, these are the people who will call OSHA. And when you say, well, who called you? Well, the police did, the fire did, whatever. General scheduled investigation, they look at Dodge reports, they look at the phone book, they drive around, and they show up. Right? Follow-up investigations, those aren't used very often. Usually that's where there's been citations issued. I rarely see follow-up investigations because normally, at least with construction, you're off the job site by the time there's an opportunity for a follow-up inspection. But OSHA is certainly entitled to go into a follow-up inspection, and under those circumstances, let's hope the heck that you've at least changed what they've said so they don't do an imminent danger procedure. Okay. Consultation services. And this is where you invite OSHA onto your job site or into your plant or whatever and say, I would like you to conduct an inspection to give me advice on, I'm sorry, I'm ruining this guy's lighting up here. I want some advice on whether I'm in compliance, what can I do? A lot of companies think, you know what, that's the right thing to do. Get them out here and prevent them from giving us trouble later on. The problem with that is that if they find anything that they consider to be a serious violation and you fail to abate it, they can cite you. All right, so when you say, well, they can't issue a citation for a consultation service, that's true, unless they find a serious violation and you refuse to abate it. And anyone here has ever talked to an OSHA inspector, Pete, you know that you don't always agree with their interpretation, right? Yeah, I think. All right. Yeah.
Voluntary inspection, so they cut the agreement with the 9 times out of 10 the general contractor not to cite them, but they will cite themselves in that case.
Well, yeah, that doesn't apply to you. But general contractors do nothing but look out for their subcontractors, right? Especially with respect to OSHA. Okay. Yeah, I know, that's completely BS. General contractors, and by the way, I have a couple of general contractor clients. I know, I'm embarrassed by it, but they pay the bills. But their view, at least the general contractors I represent, is they require a warrant every time. And guess what happens? OSHA leaves them alone a lot of times. And when they require a warrant, what they do is they say, okay, we've sent OSHA away, we've required a warrant. Now, any of you guys here, clean up your act, because if they do come back with a warrant, you know, and they do cite you, you can't say I wasn't cooperative. Tell me you wouldn't like a GC like that on every job. Okay, but what typically happens is the general contractor is looking out for his own behind, and that's a problem. Okay. OSHA compliance officer. Okay. As you all know, safety background is not required. Most of these people are trained by the agency. And as I think you probably, if you're reading the newspapers, OSHA has just hired a bunch of people. All right? And these are people who are being trained by the government. Okay, these are not people who have any idea what steel erection is about. They've never been in a crane. They think a crane is what you see on the golf course flying across the water. But they're given training. They're not particularly knowledgeable. And what happens is, just like with lawyers, and I guess just like with steel erectors too, you do one kind of building, you're an expert, right? You know, you ever do a 3-story church with a something? Oh yeah, we're the best in that. You do one building, it makes you an expert. Same with lawyers. You ever do something like that? Oh yeah, I'm the world's leading expert on that. Well, same with these OSHA compliance officers. They go and they inspect a steel job and they like it. Then they become experts in steel erection, and then they start inspecting steel jobs. Or you get guys who love cranes. All right, and what that means is that they usually are knowledgeable in a very narrow area. So you may be doing something absolutely horrible, unsafe, but it's not something they're familiar with, and they're busting your chops on something that they know about. Again, that's one of the problems with dealing with a guy who's been trained by the agency and looks like Harpo Marx. Okay. The problem I have with management mindset, and I'm not talking about you guys because you've heard this before, but maybe as new people get into the business and you're trying to mentor them, okay? there seems to be an initial mindset that OSHA is there to help and that OSHA is only concerned with employee safety. And cooperation is what we need to do. My God, I can't piss them off. If I do that, they're just going to cite me. I got to be nice to them. I got to give them donuts. I have to offer them coffee. I have to be as sweet as can be. Just let them do whatever they want, or else they're going to get mad. All right? How many people were here? You don't have to raise your hand. Just cough. All right, for you. Now, how many people were here last year? Well, I think it was last year in Myrtle Beach when I was talking with the former area director out in Colorado. What's his name again? Okay. He agreed with me that OSHA is not concerned with safety. They're concerned with compliance with their regulations. Okay? That's what OSHA is concerned with, not necessarily safety, but, so the correct mindset for management has to be that the inspector is an intruder. He's concerned with compliance, not safety. If he hasn't been trained on a particular regulation, he's not going to recognize the problem. All right? So he's only interested in compliance, and that while you want to be civil and professional, it is, after all, against the law to murder an OSHA compliance officer. All right? Federal and state. Okay? Blind cooperation is rarely appropriate. Okay? You have to have the mindset when OSHA shows up that the workplace is filled with minor technical violations that could end up costing you thousands of dollars or lost time or things like that, and that you've got to control the situation, not let the situation of the OSHA inspector control you. This, by the way, is our safety director, and this is the guy that I want representing me. Okay, sorry. I just love that picture. Excuse me, let me go back. I have no idea who that guy is, but that guy should inspire you. You should look at that picture right before dealing with an OSHA inspection just to get in the right mood. All right. Why doesn't cooperation work? OSHA cannot give you a break. If the compliance officer sees a violation, he is supposed to cite you. In fact, in some jurisdictions, Virginia in particular, they will cite you even if they are convinced that you have an employee misconduct offense. What they do is they cite you, you go to the informal conference, and at the informal conference they have a settlement agreement with you that vacates the citation because it's employee misconduct. And why are they doing that? To increase their statistics, right? We cited 7,000 horrible steel erectors in Virginia this year and settled 6,599 cases. All right, so that's one of the reasons why they can't give breaks. I've never seen evidence that OSHA responds better to kindness. I never have. Human nature being as it is, who do you want to deal with? Let's say you want to do you want to deal with somebody who's nice and cooperative? Is that the place you're going to go back to time and time again? But if somebody treats you like you're the plague, nice to you, but get out of my face, I don't need you, you're bothering me. You don't want to go back there, right? Well, I think that's what happens with OSHA inspectors. You may anger them the first time you give them some grief. But what will happen when they go and they say, okay, we got 2 inspections, 2 complaint inspections. We got Phoenix and we got Baysden. And one guy says, nah, I ain't going to Phoenix. Last time I went to Phoenix, they did nothing but trouble, but Baysden gave me coffee and donuts. So where's the OSHA inspector going to go? He's going to go to Baysden. He's going to send somebody else, okay? And difficult employers are avoided because they require more work. Okay. On attitude, remember, a lot of times I preface these talks by saying, I represent a lot of steel erectors, and I know that no one here wants to hurt, much less kill an employee. And I mean that's from a moral standpoint as well as a business standpoint. I've never ever seen anybody that I represent being involved with an accident or a fatality where they weren't devastated by it as well, all right? However, okay, the health and safety laws of this nation treat you like criminals, okay? Do you realize the OSHA enforcement policy is not to make safer workplaces, it's to inspect them and penalize them for violations. All right? They've set it up so that you're treated like a criminal. So remember that, okay? When you're dealing with OSHA, you need to take full advantage of your rights, including those normally invoked by criminals. Okay? And what I mean by that is that if you are a drug user, okay, and you have a stash of marijuana in your house, and a cop knocks on the door and says, "We've had some complaints that there may be marijuana being sold at this house. Can I come in and look?" What's the correct answer? No. Get a warrant. And then, I don't know, I've never, sold marijuana, so I don't know whether you flush it down the toilet or whatever. But you need to get time to come into compliance with the drug laws, so you send the cop away for his warrant. All right? You got to have that mindset. Because you may not have a stash of marijuana, but you've got some idiot iron worker out there who says, "Well, I can go across here without being tied off just this once because it's a pain in the neck, to tie and retie and, change my anchor point and all of that stuff." Okay. All right. This is the perfect safety officer. Big and mean and nice. Hoss Cartwright. Anybody in this room too young to remember Hoss Cartwright? He was on Bonanza, okay? Everyone in there needs to have a safety officer, or the president or the vice president of the company, if you aren't big enough to have a safety officer, who's intelligent, thorough, detail-oriented, has a nice manner, but not afraid to tell a big ugly guy in a biker bar to sit down and shut up. To me, that's the perfect safety officer, someone who can go up to an OSHA compliance officer with a badge, okay, and with a notebook and a camera and a hat, and not be intimidated by him, and say, someone who's not afraid of the cops or OSHA, someone who knows how to say no, and somebody who knows when to shut up. Okay, that's the perfect guy. Is Steve Burkholder in here? Okay, Steve had a fatality. He'll be at the 1 o'clock? Okay. Steve had a fatality a year and a half ago, and no citations. All right? Guy was run over on a construction site by a forklift. All right? And he had so gotten his foreman to say, "I don't talk to OSHA, without the safety officer here," that the state police, who were the first on the site, asked him what happened. He said, "I'm not talking to anybody till my boss gets here." All right? They were ready to take him away in handcuffs for not cooperating, but you know what? He's my hero. He didn't get arrested. We had plenty of time to deal with the situation, and he didn't say anything stupid, because what happens if you tell a cop what happened during an accident, and either you don't know exactly what happened, or the cop takes it down wrong? What happens to those statements? They share them with OSHA, right? And they can be used against you. This guy is my hero. I told Steve that he's got to give this guy a bonus. And as we said, we had no citations. That's got to kill OSHA, right? When there's a fatality on a job site, they're going to want to cite you for something. And they didn't cite us for anything. And I credit the foreman for, he wasn't the safety officer, but he knew when to shut up. Okay. Let's say we're talking about those of you who have shops, and I think almost all of you have at least a small shop connected with your business. You need to have the receptionist trained not to let anyone in the facility. All right? Because you're paying somebody $25,000 a year, very nice person, and you know, somebody comes and says, I'm from the government, I want to go in and take a look at something. Okay, you know 99 times out of 100, that person's going to say, oh, yes, please. Do you want donuts and coffee? All right. What you want to do is you need to train that person to say, no. Foremen should know what to do. You shouldn't have anybody in a foreman's job who doesn't know what to do if OSHA shows up on the job site. And if you're like every other company that I represent, you promote people who are your best employees into supervisory positions, right? And the best employees don't necessarily have good supervisory skills, all right? I'm sure there are plenty of people out here in this room who are great managers. You've got the personality for it, you've got the ability to lead people, okay, you've got the ability, you've got common sense, and you would make horrible iron workers, right? Okay, so think about why you're in charge. That's why you want to promote people, so that foremen not only know what to do, but are the kind of people who can do it for you. Okay. And all personnel should be trained to contact the safety officer or the director immediately to handle the situation. What do you do if the safety officer is not available? You say that, I'm sorry, the safety director is giving an electrical demonstration? There's someone else that can help you? No. What's the correct answer? Make the compliance officer wait. I have never, ever, and those of you who have been involved in inspections with me, I've never, ever had an OSHA inspector refuse to wait. And I've even seen the OSHA inspector leave and say, well, I can't wait forever. I'll come back later. Make the compliance officer wait, because you don't want OSHA or the state agency inspecting without the safety officer or the head guy going around with them, and you want to stop. Now, what happens if the GC, the general contractor, allows the OSHA inspector on the job? I think you just stop work. You just get people off the building, bring them into the trailer, and wait until the safety officer shows up. And they say, well, why'd you stop work? What's the answer to that, if the OSHA inspector asks you that? Because you're here, right? Why'd you stop work? Because you're here. Okay, and my instructions are that the person who deals with OSHA is our safety officer, and he's an hour away, you're going to have to wait. Well, why'd you stop work? Because those are my instructions, to stop work. Okay. Now, you know that you've got the right to insist on a warrant. I know I've gone over this before, but in your facility that you control, not the construction site, but certainly your shop, any facilities, if you're involved in fabrication, you can insist on a warrant, and OSHA needs probable cause to get a warrant. And just like CSI, you need to have probable cause. Probable cause, I mean, it means that they just have some sort of evidence to convince a judge that there's a violation of the Occupational Safety and Health Act going on at the time. Okay? I say, congratulations, your suspicious behavior entitles you to a free massage. Okay. And I say, at the job site, you're at the mercy of the GC, you're at the mercy of roads, alleys, and buildings surrounding the job site. As Sherry, if you've heard them talk about, the Assistant Secretary of Labor in charge of OSHA was staying at the Peabody Hotel when L.R. Wilson was erecting steel across the street, and Joe Deere, who was the Assistant Secretary, looked out, saw a couple of iron workers working without fall protection, and he called the office. All right, so that kind of stuff happens. By the way, we won that case, but even so, it was one of those sad cases for Wilson because it cost him a lot of money to win, but one of the good cases for me because it cost them a lot of money to win. All right, and by the way, this is probably a good time. Duff said, asked me if I was going to include it. You're aware that OSHA, we're talking about big labor having influence on the current administration. We believe as a result of some pressure the Iron Workers Union has put on on OSHA. They have rescinded an interpretation letter dealing with an employee who's tied off, but there isn't decking below him, that they will consider that a de minimis violation, as well as there's a thing involving shear connections, whether they're done in the field or changing again, whether they're going to cite that. The association has retained my firm to challenge these two changes, and it looks like we are getting close. Keep it quiet, but it looks like we're getting close to a resolution that might be favorable with the Occupational Safety and Health Administration on that. Okay, so stay tuned. The minute anything happens, I guess there'll be a broadcast email to all the members, but we're pretty sure that this was done quickly under pressure from the Ironworkers Union, and now they're trying to figure out how to save face. Okay. All right, what happens if OSHA shows up? You've got to ask questions. Before that person even goes out into the site, you've got to say, why are you here? He says, a complaint investigation. Can I see the complaint? There's nothing wrong with interrogating these guys and finding out why they're there. How was my company selected? If you can't get answers, consider requiring a warrant or refusing to cooperate. If you're on a construction site and the OSHA inspector won't give you any information, you might want to consider just saying then, we're not cooperating with you. Right? Now you're going to have to deal with the general contractor, right, who's going to want to give you grief, but I think pushing back is much better than just going along, because the general contractor is not going to pay the citations if you get them. Okay. You need to take the compliance officer, if they're coming to inspect you, and it's not a wall-to-wall inspection, take them to a private room or the job trailer. All right? Don't let that person walk around the job site. Don't talk to him on the job site. Because that's what happens. You're on the job site instead of being in the trailer, and you're asking him questions, and you've got ironworkers swinging back and forth, because how many times have you seen this? And I've seen it a lot, where an employee knows OSHA is on the job site, and he decides he's going to get cute and do something stupid. All right? Happens all the time. So get that person, the compliance officer, into a private room or the job trailer, and always control his contact with employees. If he says, I want to talk to your employee, what's the correct answer? No. He says, well, I have the right. He says, well, you have the right if you have a warrant that includes employee interviews, but I don't have to stop the work. I don't have to make my employees available. Now, it gets a little different if there's an accident investigation. And since I promised to stop on time, I don't know how much farther I'll get to talk about a fatality or an accident investigation. But if you do have a serious accident, sometimes employee interviews are unavoidable. But what I recommend you do is, if you have a fatality or a serious accident, get those iron workers off the job site immediately. Okay, preferably before the police can get there and say, nobody's going anywhere. All right? And you need to sit down with those employees either off the job site or on the job site and find out what happened before they talk to the police, or before certainly they talk to OSHA. Now, you may be stuck at the end of that day, or with the police, of having them talk to your employees, but you need to get to them first. Going back to the Steve Burkholder fatality, the S&R fatality I was telling you about, we put together what happened. This guy gets run over by a forklift, all right? And I mean, big wheels crushed him, and nobody knew what happened. We had to interview 4 people from different angles so that we could put together what happened, so that by the time OSHA interviewed these people, we had talked to them and everyone knew what had happened, so that the stories were consistent. All right? And that's essential. You've all seen that if we started, if I whispered in Paul's ear here and he whispered in Sharon's and it got around, by the time it got to Bruce, it would be completely different than what I told Paul. All right? That's what happens unless you get your story straight from the get-go. And I got to tell you, when you do have a fatality or a serious accident, people are wigged out. And you got to have somebody there saying, wait a minute, let's calm down, let's figure out what happened. We've called 911, we've gotten the rescue, we've done what we can. Now we've got to be thinking what happened, think about saving the business. Yes?
The scenario you described, where you send all the employees home before Osha and the police arrive.
Yeah.
Once either of those show up, they ask you, if they ask you, I'm sure they would, who the employees, their names that were there, are you required to give those names?
You're not, but when the police ask, I would cooperate with the police, all right? The fact that they're off the job site, and you say send them home? No, I would send them somewhere, either to the office or to the hotel if it's an out-of-town job. But if the police ask for the names of the witnesses, give them the names of the employees. If OSHA asks for the names, say, I'll get back to you. All right? I need to talk to my safety officer. Does that answer? Look, cops, I don't know if there are any ex-cops in here, but I've had ex-cops working for me. They're delightful, wonderful people, but cops can be jerks at times. And like I said, those guys were ready to arrest Steve's foreman for not giving them information. I don't want to see that happen. If it gets at that point where you're sitting in the back of a cruiser with your hands handcuffed in the back, maybe that's the time to say, well, okay, let me get you those names. All right? Okay. These are when you need to insist on a warrant. Your plant's not ready. The plant is operating at a high level. This happens all the time. If you're involved in fabrication or something, and the plant is gearing up at 100% and it's at capacity, that's the worst time for an inspection, right? You certainly don't want somebody walking around distracting your employees. And like I said, if it's on a site, on a construction site, and today is the day you're scheduled to erect the biggest, ugliest piece of steel in the history of mankind, right? And there's an OSHA inspector on the site, what do? Change the sequence, all right? And if the general contractor gives you a lot of grief, you make up some BS story or whatever, but you change the sequence. You don't do the toughest, most dangerous thing when OSHA is on the site, correct? I insist on a warrant when OSHA is not cooperative, or if the complaint's from an unreliable source. They said, I'm here for a complaint. Well, who's it from? Can't tell you. Well, what's it about? Can't give you any details. And they say, just like one of my favorite movies, Caddyshack, I ain't paying 50 cents for no Coke. He said, well, you ain't getting no Coke. So if somebody says, if the OSHA inspector says, I'm not giving you the information, and you say, well, you ain't getting no inspection, and send them out. If OSHA does have a warrant, this rarely happens because it requires paperwork. All right, and OSHA hates paperwork. Let me tell you what happens typically when one of my clients insists on a warrant, like the general contractor. They're a great company. They do a lot of strip shopping centers. And what'll happen is they'll insist on a warrant. Then John Krasnoff from Maryland Occupational Safety and Health will call me, and he'll say, Frank, you really going to make me get a warrant for this? I'll say, well, John, what are you really interested in doing? He said, well, he really wants to see this or have this. Or I said, okay, Thursday, 10 o'clock, we'll arrange for him to meet in the trailer with this guy, and we'll let him look at the crane. And that's it. That's what happens. Even when you insist on a warrant, they rarely get a warrant. What they'll do is you'll get a phone call from somebody who will say, wait a minute, is there a way we can work this out? And if you're cheap and you don't want to hire a lawyer to do that, and I understand why. I mean, I addressed a bunch of 5th graders 2 weeks ago because my daughter teaches 5th grade and asked me to come in and talk about how to argue because they're doing some segment. And I started out and I said, what's it like to be a lawyer? And I said, I make $405 an hour. And I got to tell you, from the rest of that time, that's all they could think about, all right? So I know it's scary. And I told him, I said, don't tell my mother because she knows I'm not worth that much, all right? But I understand it's expensive. If you decide you don't want to pay a lawyer to deal with it, negotiate. I mean, that's what you do anyway, right? When you're closing out jobs or you're buying, negotiate with OSHA. When you send them away for a warrant, when they call back and say, okay, you say you're going to get a warrant, why don't we talk about working out the parameters of an inspection? And you control it and make sure that you're ready for it. Okay. If you allow an inspection, okay, if it's a complaint inspection, limit the investigation to the subject of the complaint. If you have a fatality, limit the inspection to the fatality. If they say it's OSHA policy to do a wall-to-wall inspection after a fatality, what is the correct answer to that? Well, your policy doesn't trump my Fourth Amendment right. Okay? So, we'll limit the inspection to the fatality, and if you want to do anything else, you're going to have to get a warrant. Guess what? They will back off, and they have backed off every time. Keep the inspector from observing other parts of the plant or the job site. Consider shutting down, this is what I said earlier, some operations while the inspection is taking place. If you are operating a press brake or a shearer or something like that, okay, you shouldn't be using it while OSHA is on the site, correct? You should dust off the guard, all right, put it on, and then leave the machine there with the guard on it, and during the inspection, not operating, and then when the inspection's over, you can take the guard off and put it on the side and go back to your job. But you're not going to be doing that kind of stuff during the inspection. And I said, never agree to a wall-to-wall. Okay. Accident investigation. All right. There should be, yeah, I was waiting for my wife's reaction. She hadn't seen this before. Okay. All right. You should have a crisis plan in effect for an accident investigation. If I have time, I'll go through that. Okay. General and scheduled inspection, make OSHA wait, make a determination if you're ready, make up some excuse why today is not good. Those are vultures, and vultures are used to waiting. That's why that's in there. Okay. If you engage in a walk around, and Bruce and I were talking about this earlier, take a camera and take notes. If OSHA takes a picture, you take the same picture, all right? And your safety officer ought to be doing that. Keep your mouth shut. I will get you the answer is a proper response. Yeah.
I was just curious, what happens when you tell them, no, they can't look at something else, and they just say, well, I'm here, I'm going to do it, and they walk off and start looking around? What right do you have to...
Okay. Good question. Yeah. Okay. If an OSHA inspector says, I'm going to look at it anyway, you're not keeping me from going in and looking at that. Okay? You write that down. He said, you can't keep me from doing it. Don't wrestle him to the ground. Don't beat him up. You know, don't, no. He said, can you call the police? No. Let him inspect, and that kind of evidence, any evidence he gets, should be excluded. And I guarantee you that if his boss finds out that he did something you told him he couldn't do, he's going to be in trouble. All right? So tell him no. But you're right. If you manage to piss off an OSHA inspector so much that he does that, congratulations. You've done exactly what you need to do. All right? Okay? If you've said no and he hasn't reacted well to that, you've turned that inspection into a problem for the agency. And whenever, like I said, everybody here has technical violations daily, all right? And given you this example before, but when I used to work in a bakery, a big bakery, I used to time the paddle, which would have crushed my arm, probably cut it off if it met at the right time to scrape down the bowl. I was supposed to turn it off, take it out of gear before I scraped down the bowl. I don't do that. That takes too much time. It's ridiculous. So I would time it so that the paddle would be on the other side. You have employees who are doing the equivalent of that every day, right? They're saying, you know, all I'm doing is going over to get a bolt. All I'm doing is this. You know, it's going to take me 5 minutes to climb down and do this and disconnect and do that. And I'm just going to walk across. All right? So you know that that's going to happen. So you have to be cognizant of it. All right. You lead the inspector. Don't allow him to set his own course. All right? So when a inspector's on the job site, he says, "What's over here?" "There's nothing over here." He says, "Well, what's over there?" Or he said, "I'd like to look over here." You say, "Well, no, I think what you really want to do is look over here because this is where the work is taking place," or whatever. So steer him around, and a lot of times you can follow him. Employee interviews, I don't like them. They're scary. The number of times that I've had an employee, you know, where they've asked, "Have you had training?" And they say no. "Have you been trained on this?" No. But they've been to half a dozen toolbox meetings on the subject. They were trained when they were first hired, whatever. One of the things that you ought to do with all your employees is prepare them for the possibility that someone's going to ask them someday whether they've been trained. And the correct answer is yes. You tell them, you know, you've been trained, and if OSHA asks you if you've been trained, the answer is yes. Or if you want to say, "I've been trained on a lot of things. You know, this company does a lot of training," anything like that. But you want employees to be able to say that. The problem with employee interviews is employees are nincompoops sometimes. And they say the worst possible things. They don't remember what's going on. And can you prohibit OSHA from interviewing without a warrant? Absolutely. And can you control the time? Absolutely. One of the things that new OSHA law that I mentioned earlier may do is may make employee interviews mandatory and require employers to pay for employee interviews. I mean, that's pending, but I still think that's a Fourth Amendment problem, so I don't know whether that'll go through. Okay. OSHA usually wants private interviews. If you agree to private employee interviews at some point, you should have your employees say, "Look, you have the right to have to be interviewed, but you also have the right to say you don't want to be interviewed. And I would like you, if OSHA asks to interview you, that you say no." Now, if it's an accident investigation, it's different. You say, tell them what happened, but limit it to that. And you can say, "By the way, you know, you can ask to have me present. You don't have to, but you can ask to have me present." And as you know, 99 times out of 100, the employee will say, "Yeah, I'd like you there." Well, make sure you tell the OSHA inspector you want me present. And OSHA has to honor that request. So you should be telling her, but if your employees don't know that that's what their rights are, they're not going to do it. Because they have the same sort of mentality we talked about earlier. It's the government, I better do whatever they say. And one of the things I also tell employees to motivate them, OSHA's position is that if you're violating safety rules, we're supposed to fire you. If we don't fire you, we'll get citations. So you've got to understand that OSHA isn't necessarily there to make sure that you're safer. They want to make sure that if you're violating their regulations, that we discipline you or fire you. So think about that before you go and give them information. Yes? Correct. I mean, did you all hear that? You know, first of all, making them track track them down at home. While you don't want them doing that, again, a lot of times they won't do it. They won't follow employees to their homes, but you need to prepare the employees for that possibility, and you need to tell employees, you know, what the consequences are with OSHA if they cooperate. All right.
Can I get one of those 900 hotlines as my employees' cell phone?
Sure, but don't do it every time because they'll catch on. Yes.
I got a whole list of them.
I'm sure you do.
I'm seeing more and more often, and I think you touched on this earlier, that the GCs are entering into partnerships with OSHA for voluntary inspections and stuff like that. When we're bidding jobs, should we be making qualifications in regards to those inspections? You know, like, should the safety director be present, or should they be announced, or something like that?
Yeah, I mean, I think the question presupposes the answer. Absolutely. What the general contractor normally has in the agreement is you're going to follow OSHA regulations, you're going to follow all of that, you're responsible for all the safety, and you're going to indemnify us for any violations that we get, any citations that we get as a result of your work and arising out of that. If you can get something in the contract that says, that we have to agree to any sort of inspections, that we have to, if you invite OSHA in and there's a disagreement on an interpretation of a regulation, that our interpretation will be given weight, things like that. If you can get it in, by all means. But, as a practical matter, the GC doesn't want to put anything that isn't in his form, right? Right. Okay. Okay. Again, this is what you need to do. Train employees what to say. Never volunteer any information that can be used against the company. Never admit a violation. At most, say you'll review it. Don't help OSHA prove its case against you. I don't care how uncomfortable the guy makes you. It's okay to say, I'm not going to answer that. I'll get back to you. All right, I know it's human nature, but don't be the one when they say, how long has this condition existed? And say, I'll get back to you. You don't know how long this has existed? I'll get back to you. All right? If you say 2 weeks, 3 weeks, a day, whatever, they're going to use that as an admission against you. Don't ever volunteer any information other than name, rank, and serial number, unless you are unless you're a safety officer who really understands how to talk to the OSHA people. And you should always show off your safety expertise if you do have it. And like I said, show that employees know how to use lanyards. Never mind. I apologize to the women in the room, but that's the best lanyard slide I could find. All right. Well, it's the only funny lanyard one I could find. All right, just quickly through, if you have a fatality, remember, events will many times take over for you. Remember, these are your concerns, health and safety of your employees. You want to avoid liability, obviously. You want to avoid OSHA citations, especially ones that could carry penalties. You want to preserve evidence. You want to preserve the company. And you want to prevent opportunists from exploiting the situation. And who are those opportunists? Lawyers. Because remember, if somebody dies on a job site and he's your employee, that sometimes is better than having someone who isn't your employee die on a job site and they can somehow tie your company in to the death. Because unfortunately, under American law, or fortunately, depending on how you look at it, if one of your employees dies, he's pretty much covered by the workers' comp laws, and he can't sue you, okay? But if it's not one of your employees and you're negligent, and your negligence can be proven by an OSHA citation, you may be responsible for the fatality of someone else or a serious injury or things like that. And perhaps I just got a couple more minutes, I can close by saying, really, really, really read those indemnity clauses that the general contractors ask you to sign. All right, because what can happen is if the general contractor is negligent and you're negligent, all right, say you're both negligent, and one of your employees gets seriously injured or dies, he sues the general contractor for his negligence. And the general contractor says, I'm covered by this indemnity clause. All right? So, and just, you can write this down if you want, or I'll follow up. You don't want to agree to indemnify the general contractor for any liability arising out of your work. That's way too broad. That means even if you're not negligent, if somehow they can connect it to steel erection, you have indemnified him. You should indemnify your general contractor for any liability arising solely out of your negligence. All right, so that's the difference. So when you're looking at these indemnity clauses, if you're indemnifying somebody arising out of your work, you're saying if one of your guys gets killed and he sues the GC and he collects, you're responsible.
Be real careful on those, and as you know, because they're worded such that if there's a joint negligence, it says that if you are 1% negligent and the general contractor is 99% negligent, you stand in his shoes. You take care of it.
Correct. Solely your negligence. That's important. Yes.
So if you have the opportunity to negotiate something into the contract,
Yes.
market is hard to negotiate anything into a contract. What is a 10-sentence word you try to put in there in regards to this? You just said solely out of our negligence.
Correct. You're indemnifying.
Solely out of our negligence.
Yes. Solely out of your negligence. That's the best possible thing, because it's reasonable. If somebody gets sued because you screwed up, the general contractor, then you ought to be responsible for it. But if it's not, if you're only partially responsible, as Richard said, only 1% responsible, you don't want to end up being 100% responsible because you agreed to a general indemnification clause. All right? Okay, it's 11:30. Any other questions? Yeah.
Clarification, if there has already been an accident, you cannot enforce it.
Oh, absolutely. Oh, okay. If there's been an accident, you can request a warrant. Now, at a construction site, the GC is going to let them in, right? So, but you can insist on a warrant for the interviews. If it's in your shop, you can still, you let the police in, you let the fire in, you let the ambulance in. The OSHA inspector says, well, I want to come in. And say, no, you not so fast. You can do that, all right? And if the police say, we want him in here with us, we're going to say, well, then it's over our objection. And anything he sees, he can't cite you. All right? Any other questions? Guys, thank you. I appreciate it.